Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyers. Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm, are your hosts. They're practicing attorneys here in North Carolina. Offices conveniently located Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, Gastonia, and Morehead City. I'm Morgan Patrick, consumer advocate. Each and every week we get into legal topics. We have these discussions. You may have a situation you're facing where you've got questions and you need some answers. You can always call the firm, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call is about. An attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the show, questions@theoutlawlawyer.com. We'll answer them on a future broadcast. And check out the website, theoutlawlawyer.com. Gentlemen, we're going Halloweeny.
All right. Yep. This is I don't know if that's a real word. I like that word.
Yeah, it's a real word. It is now.
I was going to say it is now, but I'm guessing no before now.
I'm making a firm legal ruling, and we're going to go ahead and add it.
A precedent. This is a Halloweeny case. And so our first case is, again, anytime we talk about a case, we want to know what court's hearing it. We want to know if it's state or federal. But this is Stambovsky, which I'm sure I'm mispronouncing, v. Ackley. And this was New York. This went to the New York State Court of Appeals. We recently had another New York State Court of Appeals case. I can't remember which one it was. I think it was
They got some good cases that way.
I think it was the elephant. Is the elephant a person? Does the elephant have civil rights case? You remember that one?
Oh yeah,
it's not. All right,
it's one of my favorite cases, man.
It's neither here nor there, I guess. All right, Stambovsky v. Ackley. So in this case, Ackley owned a house. I can't remember. We're in New York. I can't remember what city or town we were in, but we're in New York. And Ackley owned this house that, according to local folklore, local legend, was a haunted house. He had kind of advertised it as such. I think they did some tours. There was he had talked to local reporters, national reporters about how this. I think there was this a poltergeist? I think
basically the seller himself is the one who put it out there that the house was haunted. He's seen apparitions. He had it really publicized that fact.
So he really played it up, and he owned this house for a while, and then they put it on the market and listed it with a real estate agent, went on their local MLS listings there. And so Stambovsky was not from the area. He was moving in from out of town and had gone under contract on this house, and then put down a deposit, and then found out, and I didn't see how he finally found out. But he finally discovered.
He probably just read. It doesn't seem like this was a hidden fact. It's just he was coming from out of town. I think it was actually well known in the area, and I'm assuming it's a little bit of a smaller town. So probably, you know how small towns are, Josh. It probably got to him fairly quickly after it was known he was purchasing it.
And so this. Yeah, he didn't have knowledge, and so they had gotten. We won't drag everybody down into the contractual process. But anyway, he's at a point where he can't really get out of the contract anymore. This was not ever disclosed to him. He discovered it, and it was concerning enough where he decided he no longer wanted to buy this house. Didn't want to lose tens of thousands of dollars in deposits and inspections and all that good stuff. And so he sued, and in the trial court level. Caveat emptor, buyer beware. At the trial court level, they said, hey, this is on the buyer. The seller has no duty to disclose any of this stuff. In most states, the seller does have a duty to disclose some things, right? So in North Carolina, you have to disclose material facts, right? If the plumbing, is hanging on by a thread, and at any moment it can go, and you've had problems before. This is something that you would have to disclose. That's a material fact. Here, there's no in New York anyway. There's no statutes. There's no case law. There's no rules. There's no requirements that you disclose that you think your house may be inhabited by a poltergeist. I suppose that's how you'd put that.
Yeah, that's how you put it, man. It's a good way to frame it.
Right. So, and he said in the trial court said, hey, you got nothing here, denied. You're going to have to buy the house or lose the money or what have you, lose your deposit. So he appealed it to the New York Court of Appeals, and they kind of they kind of went a different way. Did you see that?
Yeah, I saw that, man. The New York Court of Appeals is known for being a very ghost-friendly court.
Yeah. So they said your courts kind of look at this two different ways. You've got, contract law, right? Under contract law, is there any way I can get out of this? You can make your arguments. And sometimes the courts will go to what they call like equitable arguments and be like, all right, well, as far as the contract goes, you're stuck, right? The seller didn't do anything wrong. You're stuck. But sometimes they'll go and take these equitable arguments where they're like, but in fairness, should you have to do this? It's kind of like a last ditch effort where the court kind of wants to make things happen. And so the court here, they sided with the buyer here. They sided with Stambovsky and rescinded the transaction, rescinded the contract, let him out of it. I was surprised.
Yeah, basically what they said is, the fact that the seller was responsible for putting all this information out there. The seller's the one who created this reputation of the home as being haunted, really publicized it as such. The seller basically can't now claim that the house is not haunted. And, they stepped in and said that it was that the seller, basically wherever the seller creates a condition that materially impacts the value of the contract, and that condition is known by the seller, but is not something that's likely to be discovered by the buyer, the seller's non-disclosure gives the basis for that rescission. So basically the fact that the seller created this and it's not something that's going to be readily apparent to the buyer, that's where this ruling comes from, which, it's like you said, man, it's interesting. It's an interesting decision. And there were some classic quotes that that were handed down by the court when they issued this decision.
I thought it was funny, we've talked about this before, but in a court of appeals case, you're just in front of, judges, but they're usually called justices. And you might have a panel of 3, you might have a panel of 7. Every state's a little bit different, but you go before justices and they just rule. You're not retrying facts. There's not a jury. The Court of Appeals is just looking at what happened at the trial court level. And so here, you had a majority agree that even though there was no foundation in law, just equitable, just rules of fairness, since, like you said, Joe, the seller helped create this issue, this poltergeist, or knowledge thereof, they were going to let the buyer out. There was a dissenting opinion, so one of the justices were just basically like, no, this is an arm's length transaction. The buyer has the responsibility to understand the quality of his bargain under the notion of caveat emptor. And so you hear that a lot.
Let the buyer beware.
Yeah. And so that's kind of the standard. And I think that's the way it is in most states. But not North Carolina, right? So in North Carolina, just to bring this back to local, you don't have a duty to disclose anything like that. You don't have a duty to disclose a lot of things in North Carolina. It's really, the buyer beware. The only things you have to disclose are things that amount to a material fact, something that the buyer is not going to be able to discover even with inspections and things like that you're aware of.
And so, and you hear that and you would think, well, a haunting, that's something that, how do you discover that? And, but at the same time, the way it's looked at in North Carolina is that is not something that is considered a material fact in and of itself, but material facts include, facts of specific importance is what we call them. So if it's something that a buyer specifically asks about and you have knowledge of it, then it can be considered a material fact. So if your house is haunted and you're asked that by the buyer and you represent to the contrary, then you could have an issue. But just a haunting in and of itself is not something that you would have to disclose. So anyone here that's listing a haunted house, you're going to be all right. You're safe.
Well, between you and me, Joseph, no house is haunted, right? It's not a thing. It's not a real thing that happens, right?
You say that, man, but funny enough, we just bought this nice, beautiful office in downtown Clayton. Very old house.
Very cool, by the way.
Very cool. One of the coolest houses you've ever seen. Anyways, I had a buddy of mine just randomly hit me up. He found out we bought this. He was like, hey, man. It's like, I see you bought this place. He was like, we were looking at that for our office. And And we were walking through it, and the realtor was like, yeah, there's a ghost boy that lives upstairs. And we completely noped out of it as soon as they told us that. No one disclosed that to us, Josh,
No, that was
before we purchased this.
That was not disclosed. But, I was going to say that in North Carolina, we don't really, North Carolina is a relatively new state. We don't have houses that are 400 years old, 500 years old, right? And I think for something to be haunted, and again, I'm no expert, but for something to be haunted, there have to be a death in the house first? Like, I don't know what the rules are.
I think usually, man, I was consulting. I did I watched some videos to prepare for this. There's Casper. Have you heard of Casper?
I have, yeah.
Yeah, he's a friendly ghost.
Friendly, I heard.
Yeah, he's a friendly ghost, but I consulted, and I think, yes, you have to have unfinished business. That's one thing I've learned from Casper. And generally, yeah, there'd have to be some kind of death in the house, man. So that is correct.
Can I jump in? I just want to ask this question. You guys deal with real estate all the time, as a big part of your business with the firm. What if there's a murder in a house? Does that have to be disclosed?
You're putting me on the spot here, Morgan. But to my knowledge, that kind of thing does not have to be disclosed unless it amounts. This is kind of always the attorney's escape clause here. Unless it amounts to a material fact. So if the house was like a crime scene that was shot up and a lot of work was done, or some systems were damaged, there are some fact patterns where it can amount to a material fact. But usually, you don't have to disclose things like that.
Yeah, I think it's basically like the situation with the haunted house, right? It's not, unless it impacts some kind of system, you don't necessarily have to disclose it unless you're specifically asked. So maybe add that to your list of things you asked. Is this a murder house? That's a good place to start. Or take it a step further. Is there a ghost boy living in the attic? That could be a question you pose.
Well, aren't you just a little bit curious about the ghost boy and maybe investigate the history of the home?
Yeah, that's the thing. I don't think I think my family actually lived here at one point, like distant relatives, and I don't think there was any ghost boys. Maybe it's just a tiny ghost man that they confused for a boy. That's possible, right? That could be a thing.
I've never heard that. So I've never heard that. It is it's one of the older houses in Clayton, I believe. So I guess it's old enough to where something could have happened, but I've never heard that. Never at all.
Yeah, and I've yet to see the ghost boy. No ghost boy interactions. I tell you, the place we came from, our old office, was actually an even older building than this building. And that place was creepier to me personally than this place now. But maybe next Halloween we do we do a show at night. We'd maybe do a seance. Maybe we take it to the next level and see if we can get this ghost boy on the air with us as our special guest.
Well, we'll have to work that out. Hey, I was going to tell you too, there's a Simpsons, right? There's a Simpsons where Marge becomes a real estate agent. Do you remember that one? Have you seen that?
No.
And she sells a house to Ned Flanders, but it's a murder house, and she's got all this guilt because she doesn't disclose it to the Flanders family, and they put.
So is that one of the what do they call the Simpsons Halloween episodes? The Treehouse of Horrors? Is that it?
That is not one of those. That is a regular. But yeah, we've been watching all those.
So you like those? Like, you'll watch those? So you have some interest in the season? Not really.
Yeah, that's about it.
It's just because it's Simpsons that you like it. That's all.
Yeah, probably.
All right, guys. The Outlaw Lawyers. We're going to take a short break. We're back. It's the Halloween edition. We're going to get into some more issues out there. Josh Whitaker and Joe Hamer are the managing partners at Whitaker and Hamer Law Firm, the power behind the Outlaw Lawyers. They're practicing attorneys here in North Carolina. Offices conveniently located in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, Gastonia, and now in Morehead City. If you have a legal situation you are facing, you can always get answers to your questions by calling the firm 800-659-1186. That's 800-659-1186. Leave your contact info, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the show, questions@theoutlawlawyer.com. We're back right after this.